Good morning, welcome to March's family team brunch. It's lovely to see so many participants joining us this morning. As the observant amongst you may have noticed, I'm not Eleanor Marsh. Eleanor sends her apologies that she can't be with us this morning. I will still be talking to you about the delays in court proceedings and whether they're creating a new status quo for children. And then Nick will be talking to you about maintenance pending suit. Before we begin, just a few housekeeping points. We'll both be talking for about 20 minutes, which hopefully should leave us some time at the end for some questions. If you have questions, please do feel free to pop them into the Q&A box, please, rather than the chat box. Whilst Nick is speaking, I will do my best to go through the Q&A box and answer in writing any of the questions that have come in whilst I've been speaking, but there will be some time at the end to deal with questions as well. If you've got any technical issues, if you could pop those into the chat box, please, and Lucy, who is hosting our webinar, will do her best to assist you. And thank you very much for joining us. So I will start by dealing with my presentation, which is the delays in court proceedings and whether they're creating a new status quo for children. Please keep your fingers crossed, everybody. I'm about to start sharing my screen that the technology works. I hope you can all see that. If there is an issue or a problem, please do shout up in the chat box. So today's presentation will be starting with the delays in court proceedings and whether they're creating a new status quo for children. I'm going to start with dealing with the legal principles versus the reality that we're all facing on a day-to-day basis in courts around the country. I'll be talking to you about a case that deals with delay and the status quo, and then finishing by talking to you about some practical steps that we as practitioners can take to try and address this status quo argument. So we're all familiar, of course, with the no delay principle at section 1(2) of the Children Act. The general principle that any delay in determining the question of welfare is likely to prejudice that child's welfare. And that's reinforced by the overriding objective in the family procedure rules, particularly relating to dealing with a case in a way that's proportionate to the nature, importance and complexity of the issues, but also ensuring that it's dealt with expeditiously and fairly. Everybody accepts the legal principles around delay and the fact that it's simply common sense that if there's a dispute about a child, it needs to be resolved as quickly and as fairly as possible so that the family can move on with their life and the child or children can enjoy their childhood without litigation looming over them. So I think the legal principles are well established. What about the reality? So I think we probably all can identify with the statistics. The quarterly statistics, which I think are always interesting to see. The Ministry of Justice published the most recent ones finishing September 22. On average, private law cases take 45 weeks to resolve from start to finish, and that is 5 weeks more than that time in 2021. The Law Society estimates that there is a backlog of 110,000 cases in the system, and the Ministry of Justice estimates it will take 3 years to return to pre-pandemic processing times. Some of you might be familiar with the CAFCAS prioritisation protocol, which launched actually in the West Midlands in July of 2021. That triaged cases, meaning that what they deemed to be low risk private law cases were not allocated to a CAFCAS officer to sit in that officer's list to be dealt with, but instead they were sent to allocation hubs where they would be held onto and then distributed when a CAFCAS officer had capacity. I think we will all recall that that left some private law disputes waiting for 26 weeks for a CAFCAS report. We've had recent update from CAFCAS to say on the 2nd of March of this year They had deactivated that protocol in Birmingham, Northampton, Stoke-on-Trent and Coventry. For those of us who are from the Black Country, I don't know whether Birmingham means the Black Country as well, but the prioritisation protocol certainly does remain in place in Greater Manchester, Essex and Suffolk and Norfolk. The next slide I'm going to show you is a graph of how the timelines have altered from March 2011 up until the most recent statistics. You can see that pre-pandemic, sort of 2016, 2017, the court was doing well in terms of processing times. That is no longer the case. So when those statistics started, Q1 of 2011, it was roughly around 31, 32 weeks, and we're now way up to 45 weeks. And other than that dip in the middle, it seems that the trajectory is very much an upwards one. We all know, of course, from our own practices that delay negatively impacts children, but we now have the benefit of some long-term research which absolutely affirms that. So in June 2022, the Nuffield Family Justice Observatory published a study called Uncovering Private Law, Anxiety and Depression Among Children and Young People. And this was a study alongside Cafcass Cymru of a cohort of 17,000 children involved in private law proceedings in Wales, and it was over a long period. So these children were looked at between 2011 and 2018, and they were compared with around 680,000 children in Wales not involved in private law proceedings. The results of that study make for some difficult reading, albeit not surprising reading, unfortunately. So the study found that the private law cohort were much more likely to experience depression and anxiety than their peers. In both groups, the private law cohort and the non-private law cohort, incidents of depression and anxiety did increase, but the rate of increase was higher in children who'd been involved in private law family proceedings, and that girls were much more likely to experience this depression and anxiety than boys, albeit that was in both of the groups. And older children in both groups were much more likely to experience depression and anxiety. But children involved in private law proceedings were also more likely to go on to develop depression or anxiety than children in the comparison group, which suggests that they continue to be at heightened risk of mental health problems even after proceedings have concluded. So there are occasions where only the family court will do, and that other forms of dispute resolution are not appropriate or haven't worked. But the results of that survey show, that research show, that children who were involved in these proceedings are having significantly negative impacts. And the longer that those proceedings go on for, the much more likely, I would suggest, that that impact is going to be felt by children. So in terms of the status quo, we have to ask, how does the court manage cases where there's been delay and an, excuse me, a new status quo has therefore been created? Status quo, of course, is by definition the existing state of affairs where we are now. It's a matter of fact. It's not for either party to establish, it's what is happening on the ground. It's long since, of course, been established that child's welfare is the court's paramount consideration. And in that making a Section 8 order, the court will have regard to the factors within Section 1.3 of the Children Act, which is the welfare checklist, which I haven't reproduced, given that I'm sure we're dealing with this on a daily basis. But the very essence, I think, of the status quo argument is Section 1.3c of the welfare checklist, which is the likely effect on him or her in any change in circumstances. And the issue that we come across as practitioners on a frequent basis is what happens when a parent brings about a state of affairs by perhaps separating and leaving the family home with the children, suspending contact, unilaterally altering arrangements, potentially making allegations, even perhaps in situations where contact has been happening prior to those allegations being made. All of these things which ultimately lead to the need to issue court proceedings. And I think we've all experienced clients who feel very aggrieved that the other parent's actions have led to the existing state of affairs, and that they've then been allowed to say to the court that that existing state of affairs should continue because of the impact on the child of any change in circumstances. There's a helpful case that deals with this, although it doesn't really give us any definitive answers. And that's the case of F, a child, 2009. This was an appeal by a mother against an order that the children should be returned to father's care, where they had grown up. This was a situation where mum had left the family home at the end of the relationship with the children. She had relocated to Worcestershire. The children's family home had always been in Nottingham. The parties' relationship had ended for the final time at the end of 2007. Father made an application to the court for live with orders in February 2008, but due to delays in the court system, no final order was made until January 2009. The CAFCAS officer gave evidence that the children should be returned to their home in Nottingham, which was where the father continued to live, that they should return to the school where they were originally educated and essentially go back to their original base. The trial judge determined that whilst a move to Nottingham would be, or a return to Nottingham would be another change for the children, they took the view that children are quite adaptable. They'd only been living in Worcestershire for some 12 months, and he didn't consider that a change in their circumstances would cause them significant harm. The mother appealed. In her appeal, she argued in favour of maintaining the status quo that had been in place since separation and throughout the life of the somewhat lengthy proceedings. And even, she said, if the court concluded that the children would be safe and would thrive in either household, the judge had failed to provide an adequate explanation as to why there should have been a change in their circumstances after they'd been living in Worcestershire for some 12 months. The appeal was considered by Lord Justice Ward, and he took the view that the trial judge had made out a reason for the change, that the welfare officer had supported that, and that the reasoning behind it was that they should return to the environment where they grew up. The judge found that it might not be the most compelling reason, but it was explanation for the recommendation made by the welfare officer and therefore the reason accepted by the judge. The appeal court went on to say that the difficulty in this case is one which has been felt as a trial judge dealing with disputes, which is that the court has a broad discretion in these matters, and that even if the appeal court is far from certain that they would have made the same decision, the appellate court has to ask itself that whether there has been a significant failure of the original court to take into account a particular set of facts, or that there was an error in principle. The weight to be given to various factors in the welfare checklist is a matter for the trial judge and not the appellate court. The problem with this jurisdiction is that the more finely balanced the case is, the more difficult it becomes to appeal it. So the conclusion from that case essentially is that the court has a broad discretion in determining the matters in the welfare checklist and the balance that is to be given to each aspect of the checklist. Each case will turn on its individual circumstances, and there may well be cases where the court takes the view that, irrespective of how the change in circumstances has come about, that the impact on the child to revert to a previous set of circumstances is just too great. I have been asked about whether it's worth having recitals in orders, in case management orders leading up potentially to a final hearing, to say that the court has determined that they won't be considering the status quo as part of its decision-making process, or that the current arrangements don't predetermine the outcome of any final order. There may be cases where that's helpful, but ultimately the trial judge at final hearing will not be bound by any exercise. They won't be impeded in their discretion and their decision making by previous recitals in orders. It's essentially what is best for that child at the time that the court is making its decision. And I fully accept that there will be parents who come away from that process extremely aggrieved by the way that the circumstances have come about. And no doubt the court would acknowledge that in some circumstances, but ultimately the child's welfare is their paramount consideration. So rather than perhaps than thinking about recitals to orders, perhaps we can think about some more of the practical considerations to try and minimize delay as much as we possibly can. The first thing I would say is be clear in your application. What is it you want the court to do and why? Set it out very clearly in the box on your C100. Be very, very plain about what it is you want, so that when your application is being looked at gatekeeping and allocation, it's very, very clear to that person that's doing the allocation where you want this case to travel. And following on from that, use your FHDRA wisely. So if there are time-sensitive applications, so for example, the impact of a child's school attendance is going to be considered as part of the overall order that the court might make, ask the court to timetable the matter through to a contested hearing. I know that's sometimes easier said than done, but be very, very clear in your position statements as to why that's necessary. We all know that the FHDRA sets the tone for the case, so use it to clearly identify issues. If CAFCAS are completing a Section 7 report, be directive about what you want them to do and what you want them to look at. We absolutely have standard orders, which we must use, but there is no reason to suggest that we can't supplement the list or edit indeed the list on the standard orders, so that CAFCAS is very clear about the issues in this case that the court needs them to consider, because that makes it more likely, hopefully, that your DRA is going to be effective in trying to resolve the dispute or indeed narrow issues, rather than being utilised as an argument to suggest that CAFCAS hasn't covered everything that you need them to. And then you're in the realms of either asking questions of the CAFCAS officer at final hearing, or indeed asking for addendum reports. My next point is, if you want the court to avoid paper hearings, tell them that you do. Paper hearings are somewhat of a hangover from the days in which COVID was a significant consideration, and they amended the child arrangements programme to enable some paper consideration of matters. There are some courts that are still doing that. So in circumstances where they will review the matter after CAFCAS safeguarding has been received, and will only list a hearing once they've considered the CAFCAS safeguarding information. If that's going to cause a delay for your client because he or she is not having contact with the children, tell the court. If they list a paper hearing, explain to them why you don't want one. Ultimately, they may require you to make a C2 application, but the benefit of actually being before the court often outweighs the cost of the preparation of an application. The next point is obviously, is Practice Direction 12J engaged? If it is, address it at the earliest opportunity. And I would say that the earliest opportunity is if you are the person making those allegations, set them out in your C1A as you would in a schedule of allegations. Don't wait for the court to direct you to file a schedule. Use your C1A as a schedule of allegations. And if you represent the person who is on the receiving end of those allegations, there is a page on the C1A form for you to respond to the allegations. Send that in. Don't wait for the court to direct you to file a response to a schedule or a or a statement in support, set out your case at the earliest opportunity. And of course, once you've done that, go back to Practice Direction 12J and the relevant case law that's followed since, and look at the allegations. Be very clear about which allegations are going to impact on the court's decision making, and carry out that exercise with the court at the earliest possible opportunity. Following on from that, not necessarily where there are allegations of domestic abuse, but of course, we often come across cases where a parent alleges that the other parent is not promoting contact, or perhaps at the most serious end of the spectrum is alienating the other parent. Use your early hearings to identify the issues. Do the children need to be joined? Is further expert assessment required? This case isn't on your slide, but I'll pop it in the Q&A box afterwards. There's a case, Re-H Parental Alienation 2019, which was before His Honour Judge Wildblood, who said about this case, there was a failure to identify at an early stage the key issue in this case, the alienation of the children from their father by the mother. By the time that it was identified, the damage had been done. Overall, there has been significant delay within these proceedings. You should also consider whether you need the court to list an interim hearing. I appreciate that the courts are going to be very reluctant to do that these days for the reasons that we've seen on the graph. But ultimately, if there are issues that the court can determine without a Section 7 report, or indeed a finding of fact hearing, ask the court to list a hearing so that those issues can be determined, and that you have sufficient time to ventilate those issues. Obviously, I would also suggest that we all look at, when we're trying to limit and minimise the impact of delay on children, alternative dispute resolution. No doubt everyone will have seen the recent proposals from Dominic Raab to look at enhancing the court's powers to compel parties to engage with mediation, and the extension of the voucher scheme. There is currently a consultation open to practitioners until the 15th of June around this possible tightening of the requirement to mediate. At the moment, the suggestion is that the court will need to be satisfied, other than in the obvious exemptions, that there has been a reasonable attempt to mediate. And the Ministry of Justice is seeking our opinion on what a reasonable attempt to mediate could look like. Does there have to be a certain number of mediation sessions attempted? Would it be the case that the court would benefit from the parties filing statements as to how much mediation has been attempted, why it's fallen apart, why they now need the help of the court? So have your say. If it's something that you particularly feel passionate about, either way, as I say, the consultation is open until the 15th of June, and I will pop the link for that in the Q&A box. Sometimes we all accept that mediation is not going to work, and if that's the case, another way to avoid delay is to be realistic. If this is a case where mediation is unlikely to help, then an application needs to be issued. But also, you might want to think about, is the court really going to be able to solve this family's problems? Do they need the assistance of family therapy? There are lots of local authorities who run the Parenting Apart programme, parenting courses, and this could potentially be run alongside the court process or as an alternative. Alternatives that we're all becoming more aware of and that are being utilised more in light of all of the delays are, of course, early neutral evaluation, which is available for children disputes where an independent third party, sometimes retired members of the judiciary, sometimes experienced counsel, will look at the documents, look at the parties' positions, the proposals, and provide their view as to the most likely outcomes. And finally, arbitration. If there are no safeguarding issues that require the assistance of experts, then arbitration can provide a tailor-made, flexible process that would avoid the issue of delay. However, I do fully accept that expense somewhat outweighs the benefits. Finally, any questions? I can see that some have popped up in the Q&A box, which I will answer whilst Nick is giving us his presentation on maintenance pending suit. But I'm very grateful to the person that asked a question in advance, well, all the people that asked questions in advance. And one of those questions was about compensation if the court cancels a hearing at short notice. I'm sure we've all been on the receiving end of that due to lack of courtrooms, lack of judicial availability. So before I did some research on this, my own personal experience hasn't been hugely positive. I've had a former colleague manage to claim back £9.25 for being sent to the wrong court, and I think that must have been her mileage from going from one court to another. But there is a HMCTS complaints process. Again, in my personal experience, the answer is often no. But doing some research on this question, I have seen a little more success from people who have exhausted the HMCTS complaints process and have then referred matters to the Parliamentary and Health Service Ombudsman, where they have reported cases, where they have refunded parties, council's fees, perhaps some elements of preparation of solicitors' costs. So I think the answer is it is possible, but in my experience and from what I've read, it's a marathon, not a sprint. So clients obviously need to be told that it's possible, but I think they do have to keep knocking at the door. Thank you very much for listening. I'm going to stop sharing my screen now so that Nick can share his. And as I say, I'll pop that case reference in the Q&A box. I will pop that consultation link also in the Q&A box. And I will try and answer your questions in writing whilst Nick is speaking. Thank you very much.
Thank you, Rachel. My name is Nick Davis, and I'm going to be talking to you today about maintenance pending suit. Hopefully, I should be able to pull up my presentation and share the screen now. Thank you. Yes, so I'm going to be talking to you about maintenance pending suit today. I'm going to aim for a brief rundown through the basic principles and some practical advice to hopefully make these applications and dealing with them somewhat less daunting. The reasons why they can be daunting are twofold, really. Firstly, there's quite a broad range of discretion, meaning that the outcomes can be quite unpredictable. And secondly, there can be some quite significant cost consequences to these applications. I should add as well that emotions can often run very high in these type of applications. You may be faced with clients coming into your offices, tearing their hair out, saying, how am I going to afford all this? We need to apply and do something quickly. On the other hand, you may have a client waving around their ex-husband or wife's schedule of income needs in the Form E, saying this is outrageous. How am I supposed to pay for all of this? So I'm going to start with the issue of costs, which may seem a slightly unusual place to start, as they're generally dealt with at the end of proceedings and sometimes can be something of an afterthought in family proceedings, but they certainly shouldn't be where maintenance pending suit is concerned. Costs in these proceedings sit outside the general rule of financial remedy proceedings as no order as to costs. The clean sheet approach is taken, however, there is a starting point within that, and that starting point is said to be that costs follow the event, that is, that success is a significant factor. That's not technically the same as the general rule within civil proceedings, but the practical effects of that may not be a million miles away from it. However, there is authority that starting point can be displaced more easily than if you were dealing with civil litigation. And one of the ways of displacing that does relate to any offers that are made. So it's important at all stages of the maintenance pending suit process to have your eye on the need for negotiation and limiting your cost exposure by sensible offers. And again, where this differs from mainstream financial remedy proceedings is the court's not limited to considering open offers. So there remains a role with offers which are without prejudice save as to costs. And particularly if you're acting for a respondent, this may be something you need to bear in mind, and that you place yourself in a very vulnerable position going into a contested MPS hearing, having nothing on the table, as it were, in terms of a without prejudice offer. I've included there a quote some time ago now from Lord Justice Moyland, which is probably only more applicable today than when it was first given, particularly in view of increased pressures on the courts, and particularly in view of some of the more recent judgments, which have been highly critical of costs incurred in financial remedy proceedings, not limited to maintenance pending suit. But terms such as apocalyptic have been bandied around in respect to the costs in some big money cases. So bear that in mind. Question you're then faced with is, from the applicant's point of view, is when should you make an application? And Lord Justice Moylan gave further guidance that it's when, on a broad assessment, the court's intervention is manifestly required, suggesting that a pretty strong case is needed. And I would concur with that, particularly when you consider the comparatively limited opportunities you may well have to set out your case in oral submissions, which I'll come on to look at in a few minutes when I deal with some of the procedural aspects of this. What principles then apply to maintenance pending suit? Well, the statutory rules in the Matrimonial Causes Act are particularly unhelpful in some ways due to the great vagary that's in there. Such periodical payments for maintenance for such term as the court thinks reasonable, which immediately prompts the question, what is reasonable? A question that comes up in many different contexts, and often, as we'll have experienced, what's reasonable to the classic man on the Clapham omnibus may be very different to the outcome that's reasonable in a big money financial remedy proceedings case. Fortunately, help is at hand with some of the other authorities on this. However, one should bear in mind perhaps the most quoted phrase in respect of financial remedies maintenance pending suit from Mr. Justice Coleridge, that the calculation is somewhat rough and ready, and that's a phrase that I find using most often to clients when seeking to advise them on the potential outcomes of these type of cases. There's some key principles provided in the case of TL and ML by Mr. Justice Mostyn, and although these principles have come in from some modification recently, they're matters which still are very much good law in a large number of areas. Beginning with the first of those, the sole criterion is reasonableness, which is synonymous with fairness. That in and of itself may not give a huge amount of guidance. However, more is provided when one goes on to look at the further factors. In particular, factor 2 in the list of Miss Justice Mostyn's, that the matrimonial living standard is very important in determining fairness. That was referred to in the case of BD and FD as a benchmark rather than a ceiling or a floor. You'll find in reality that except in cases where there's a great deal of resources available, that there's inevitably going to be a reduction in both parties' standards of living. However, what you should bear in mind is that the separation in itself isn't a reason for that reduction, and there can be a tendency when looking at maintenance pending suit claims to think the task of the court is to strip out the frivolous or the excessive and to pare parties back to the bare bones. But that isn't the approach that follows automatically. A lot will depend on what there is in the case and how the parties have lived in the past. The third point Mr. Justice Mostyn came up with, which is the one which has come in for the most modification more recently, is that there should be a maintenance pending suit budget in every case. That, as I say, has been modified to some degree. But what remains important is that maintenance pending suit should exclude capital and long-term expenditure. Now, what's significant in that is what's being excluded is long-term spending. It relates to when that spending might be incurred and the nature of it, rather than saying whether it's frivolous or non-essential. However, it's this part of the judgment in TL and ML that's come under some modification in more recent case of Rattan and Kuwad, where Mr. Lord Justice Moylan has taken the view that it's not necessary for there to be a specific maintenance pending suit budget in every case. In that particular case, the budget contained in the Form E was good enough and was close enough to what we were concerned with to not require a further budget. Perhaps more importantly, Lord Justice Moylan went on to say that not all budgets require critical analysis. It will depend on the circumstances of the case, the circumstances being, of course, resources available among others. That case came back and was considered by Mr. Justice Mostyn in the case of Collado Fuchs just last year. And Mr. Justice Mostyn interpreted that as meaning that it's not to say that cases shouldn't be properly scrutinised and indeed carefully scrutinised, but the way that's done will depend on the circumstances. And the rather poetic or artistic way that Mr. Justice Mostyn put it was the court should try to paint its decision with a fine sable rather than a broad brush. However, that was qualified by where it has the ability to do so. And that, of course, will depend on the evidence available, the time the court has available. However, in that case in particular, the court was dealing with very significant sums of money. The initial claim for maintenance pending suit there was in the region of £350,000 a month. So one can see how in certain cases the claim for maintenance pending suit might dwarf what's available for final determination in others. Where the assets are more significant and there's more resources at stake, a more detailed analysis will be justified. What then can and should go into a maintenance pending suit budget? What we're concerned with is the immediate needs of the parties. However, immediate is not necessarily what's going to be incurred in the next month or so. We're concerned, in all probability, of an interim running up to a final hearing, which may well run into many months and possibly over a year. And one of the factors in the decision in the case of Rattan was that the court shouldn't be excluding expenses simply on the basis that they're not incurred on a monthly basis. Quarterly expenses could be included, and we've all seen doubtless claims for matters such as expenses related to Christmas in a budget, and there's a tendency to say, oh, well, that's not a maintenance pending suit expense. But again, it's something that needs to be looked at in context and circumstances, seeing how long you've got to run until final hearing and what's really going to crop up between now and then. One change since the judgment was given in TL and ML is that costs allowances are excluded from maintenance pending suits. That's now put on a statutory footing by the procedure under section 22 ZA, which is a matter which unfortunately time today precludes us from going into, and is perhaps a matter for another of these talks. School fees are specifically something that can be included in maintenance pending suits, despite there being a separate procedure for those. Holidays, again, are not something that's excluded on principle. They may be something that that's considered in some cases more of a frippery, but again, there's no reason for exclusion in principle from that. Looking at the next in Mr. Justice Mostyn's checklist of factors, and it's a significant one, is his fourth, which is where the disclosure of a respondent is obviously deficient. Then the court has the ability to make what are called robust assumptions about the ability to pay. Now, these, of course, are assumptions. They're not findings of fact, and they are matters that are made where a party has failed really to address matters in evidence, rather than where the court takes a view on differing accounts given by the parties. So if a matter has been dealt with by a respondent, the court is unlikely to be delving into the truths of each party's version of events on an interim basis, unless it's very clear cut. That was something that formed a factor in the decision in Rattan, where the husband in that case had completely failed to deal with the transfer of some 350,000 to a relative overseas, and that's something which was factored into the court's decision making. So that's something to bear in mind if you're acting for a respondent, is the need to really address matters and set out your case. It's something that, of course, could be an added bonus to an applicant in making one of these applications, in that you can nail down a respondent to an early stage to explain some of their actions. The final point, and it's got some similarities to the previous point from TL and ML, is that where a party's being provided with support by a third party, the court can make the assumption that that will continue where the position of the outsider is ambiguous or unclear. So when you're putting together any evidence in response as a respondent, you should bear in mind whether there is any need for evidence from a third party to dispel the illusion that they are going to be continuing to fund your clients up until a final hearing. Should you fail to do that, you might be in a vulnerable position to this sort of assumption being made by the court. Looking then at the evidence that the court would be putting together or considering for a maintenance pending suit case, sometimes there will be specific directions in respect of this, but not always so. As was referred to earlier, the evidence will be by definition incomplete. It may well be that you don't even have Forms E before the court if the application's been made at an earlier stage. If that isn't the case, then there's a requirement for there to be some evidence of the financial circumstances of the applicant included with the application. And similarly, if a respondent has yet to file their Form E, they must file a statement of means with their response to the application. Whilst it's not a requirement anymore that there's an MPS budget in each and every case, it should be carefully considered whether you do need that. And the further you are out from the filings of your Form E, the more likely it is that you're going to need a separate budget if there's been changes in circumstances, particularly in cases that I've seen recently. Cost of living crisis may mean that someone's gas bill in a Form E filed a year ago is no longer applicable. Similarly, mortgage payments change and have generally gone up quite substantively over quite a short period of time. So that's something to bear in mind. And it's also important to bear in mind from the respondent's perspective what you're going to need in your evidence to avoid the risk of adverse inferences or assumptions being made against you. With regard to the MPS budget, it's always helpful as well if you can have that budget which makes very clear at first glance to the judge that they're dealing with MPS matters only in there, rather than them having to pick through it. Similarly, from a respondent, you may wish to file an annotated budget setting out what you say isn't proper maintenance pending suit expenses within that. Looking at the procedural aspects of this, you will, as I said earlier, have a very limited chance to make your case in one of these hearings. The Rattan hearing was somewhat unusual in that at first instance a day was listed for a maintenance pending suit hearing, and in my experience they tend to be considerably shorter affairs, sometimes as short as an hour, but generally more likely in the region of a couple of hours to half a day. But may therefore be considerable variation in practice as the time the judge has got to look at this, and there may also be variations in individual judges' approaches. Some judges may be more of a fine sable type by inclination, whilst others may be a very broad brush approach and give you very short shrift if you're taking them to £5 a month being spent on this, that, or the other. In terms of the duration of maintenance pending suit orders, they're generally made to run until a final hearing, although they don't have to do so. You may think it useful to try and have an order limited to an FDR. However, that can prove to be problematic if you don't arrive at a settlement at the FDR, because the FDR judge won't then be able to go on to consider whether the maintenance pending suit order should be continued or should be varied in some way, and you arrive in a position where there's a further maintenance pending suit hearing, potentially with all of the cost consequences of that and potential for matters to become disproportionate. The other matter to bear in mind is that it's possible to backdate maintenance pending suit applications, and it's possible to backdate as far back as the divorce petition. And if there's been a considerable time lag, that may result in a considerable sum being payable. So that's something that needs to be borne in mind. Just a final point, and I appreciate I've rattled through this somewhat, and there's a lot to be read into in these judgments in more detail, is the situation where you have a prenuptial agreement as well. In those circumstances, it's incumbent upon the applicant or those who are saying it shouldn't be adhered to deal with why that is in their maintenance pending suit application. And there's requirements set out in the case of BN and MA, but they need to demonstrate to a convincing standard that they have a likely prospect of satisfying the court that this agreement should not be upheld. Now, there'll be a greater degree of scrutiny being applied to the prenuptial agreement the longer it is since that agreement was made. But again, it's something that you need to deal with in your maintenance pending suit evidence if that's an issue in your case. I'm going to come on to look at questions in a minute, but before we do that, and whilst I've still got you all here, there's a few dates coming up for your diaries for further presentations from 3PB. The next family brunch will be on the 27th of April. That's again a Thursday as usual at 11 a.m. And Natalie Bull will be speaking there about Relocation in Children Act cases, and Esther Liu will be addressing economic abuse and coercive and controlling behaviour, pleading conduct in financial remedy cases, which is a hot topic at the moment. There's been some recent case law on that. Then finally, I'd also need to remind you of 3PB's first family conference in private children law and financial remedies, which is taking place Thursday, the 11th of May. That's now taking place in the Council House in Birmingham. We've moved to a larger venue due to popular demand, so there's still spaces available, but they may well be running out if demand continues. So have a look at that. And there's a keynote address from His Honour Judge Hess at that, so well worth going to. Before I come to look at some of the questions that have been sent in, there's a couple of questions that have come in advance that I'd like to address. The first is whether an MPS application can be instigated by ticking the MPS box on Form A. Well, the family procedure rules at 9.7 dealing with interim applications, which maintenance pending suit is one, states that this does need to be commenced by way of application notice. So it would follow from that just the box in of itself wouldn't trigger the application, and there's further provisions in Part 18 for what that application needs to contain, including setting out what you're seeking and why, and a draft order. So if it's an urgent matter, it's incumbent on you to get that application in as soon as possible. The second question I've had is, what is the attitude of the courts at final hearing to commercial lenders providing funds by way of maintenance to avoid the necessity of maintenance pending suits? The short answer to that is it depends, really, and it's something that if you're considering making an application, you should very much be considering, because whilst there's obviously costs attached to borrowing, there's costs attached to litigation, and the costs attached to the former may well be a lot less than the latter. In my experience, if you're coming before the court with debts at a final hearing, the courts will generally try to see that parties are left debt-free where possible and that their needs are met in this way. And to some extent, there may be a reversal of the pressures, in that it would be incumbent upon the respondent or would-be respondent to maintenance pending suit to be saying that the debts have been unreasonably incurred, rather than making the running as you would in a maintenance pending suit case, that it's reasonable that these sums are paid to you. Of course, it will all depend on the circumstances and the context, and it's an interesting postscript of the BD and FD case, where despite being ordered being paid maintenance pending suit of £200,000 a month, the wife in that case spent considerably beyond that, and the husband was in fact successful at final hearing in achieving an add back in respect of that. So running up debt is not without risks. And I can see a comment has been made very sensibly by Deputy District Judge Melville Walker in the chat, that a commercial loan is hard to dispute, which is certainly true, and there's an advantage here to borrowing on a commercial basis than borrowing from a family member and getting yourself in a situation of arguments about whether the loans are soft or hard. I'm just going to pause for a moment at that juncture to have a look at any questions that have come in. I've seen there's a few that have come in. There's a couple which have come in to deal with the issue of capital and how that should be dealt with. And in terms of a short answer to that, in the time available, capital is something that's taken into account. There's no hard and fast rule that applicants entitled to preserve their capital and have their needs met from the other party's income. It is something that needs to be taken into account. However, one needs to look at how much capital there is, what the pressures on that are going to be, and it will again depend on the context. But there's certainly not a rule that parties are entitled to retain their capital. It's a question. I appreciate there's no principle as to why not, but has anyone had success acting for husband seeking MPS from a wife? I'm trying to recall if I have. If it is, it's going back a few years, and there still seems to be a situation where the predominant cases in these circumstances are husbands paying maintenance to wives. But again, that depends on the circumstances and who's the higher earner in the relationship and who's got more resources. So there's no difference in principle. It can cut either way. There is a question as to the form used for MPS. That would be the application notice form. Off the top of my head, I think we're talking about a D11 on that, but I'd need to. I see Rachel nodding, but so I believe it would be a D11 for this. I'm just having another scan through. To see, there's a question about whether the same position applies in respect of costs to Schedule 1 applications. I suspect getting into the realms of costs, allowances, and all of that, it is probably more than we have time for in the remaining minute or so. So I don't know if Rachel's got any more replies to questions to give out now. Or
no, thank you. Nothing further from me, Nick. I'm hoping that the replies to the questions will have appeared in the Q&A box for the ones that have been raised for me. But if they haven't, please do feel free to drop me an email, and I'm more than happy to help.
Yeah, similarly, if there's anything arising, anyone who's put a question or who's got a question who feels I haven't covered it in the time available, then please do so. I think the last question was, even if you've ticked the MPS box in a Form A, do you still need a D11? And yes, it's my understanding that you do. So I'd like to thank you all for taking the time today. Sorry, it's been to some extent a whistle-stop tour through maintenance pending suit, but hopefully you found it helpful. And hopefully we'll see plenty of you next month and plenty of you at the conference as well in May. Thank you for the time.
Thanks, everyone.